And court calls People versus Robert Geese, 26T884. And if you'll come on up to the podium. He appears in the courtroom, and the district attorney, Mr. McGraw, appears for the people. So, Mr. Geese, are you going to be hiring a private attorney? Do you want a referral to the public defender, or are you going to be representing yourself?
Your Honor, do I have standing to speak?
Yes.
I appreciate that. It's important to me that I stay respectful. I come in peace as a non-belligerent. I would like to read this into the record, if I may.
Sure, go ahead.
First, Your Honor, respectfully, for and on the record, I am Robert Eugene Geese, a man of the Union, a natural person, as said, a non-belligerent or enemy of the state, and I occupy the office of executor and co-trustee for the Noli Me Calcari Express Trust. I am here propria persona in that regard by special appearance only, not generally. Further, I am of the age of majority by both age and averment sui juris on the record in Weld County. I deny that I am a U.S. citizen, nor do I claim to be a sovereign. I deny that I'm a federal 14th Amendment citizen, a corporation, or a statutory person. I'm a natural, freeborn national of the territory of Colorado, known as a Coloradan. If I may, I would like the court to take judicial notice that the written record thus far is incorrect. As said, I am here propria persona. I am not here pro se, nor am I here pro per. It's important that that be documented and on the record. I have submitted a motion of discovery and an affidavit of truth. Has the court received and reviewed those documents?
If you want to request discovery, you need to do that through the district attorney's office.
I've done that.
Okay.
And the documents are recorded. Sir, did you?
I have received your request for discovery. It is being processed at this time, sir.
Okay. With that in mind, I don't know how this court can proceed without the affidavit being rebutted, answered, and discovery being taken care of.
That's not how this works. So the court is not the one that goes through the discovery. If you want to talk to the DA regarding plea offers in the case, I'm happy to set it over for you to do that. If you're going to hire a private attorney, or if you want a referral to the public defender, I'm happy to set another date for you to get that done as well.
Would you like to discuss the matter now, sir?
We can, sir.
Okay.
We would pass the case and then speak off.
Yeah.
Okay, we'll pass the case for a few minutes.
Thank you.
If you would like to recall Mr. Geis when you have a chance.
Okay, sure. Court will recall People versus Robert Geis, 26T884.
And if I may correct the court, the last name is pronounced Geese.
Geese, sorry about that.
As in Canada Geese. Yep, that's okay.
Okay. Mr. McGraw?
Yes, after speaking with Mr. Geis, I advised him of the offer on the case. It is his plan to plead not guilty and set for trial today, Your Honor.
Okay.
Well, if I may,
I apologize.
respectfully, I do not plea. I don't know how I can plea, and I object to and would not consent to a plea being made for me.
Okay, so how do you want to proceed?
Well, we'll go ahead with setting up a trial.
So if you want a trial, that means that I will be entering a not guilty plea.
I understand that. I respect that. I will object to it, and I don't consent to it, but let's proceed.
All right, so I need to go through an advisement with you regarding your right to counsel. Do you understand that you have the right to be represented by counsel in your case?
Yes.
Do you understand that if you cannot afford an attorney, one will be provided to you free of charge if you qualify financially for the public defender?
I am here propria persona.
Do you understand that the charges against you in this case are driving under a revoked license and careless driving? They're both class 2, The careless driving is a Class 2 misdemeanor traffic offense that carries up to 10 days to 90 days in the county jail. The driving under revoked license is as a Class A traffic infraction and carries a possible fine. Are you under the influence of any medication, drugs, or alcohol that would affect your ability to think clearly?
No.
Do you wish to consult with the public defender before you make a decision to waive your right to an attorney and represent yourself?
No, I do not. And I do not waive my right to trial by jury.
Have you ever studied law?
I don't know how that is relevant to the case, Your Honor.
I'm trying to make sure that you're knowingly, voluntarily, and intelligently waiving your right to counsel.
I am.
Have you ever represented yourself in a criminal action?
I have.
Do you understand that you have the right to remain silent? Anything that you say can be used against you in court?
And I choose the fifth. I won't answer any more questions.
Do you understand that you have the right to confront the witnesses against you and cross-examine them?
Absolutely.
Do you understand that you have the right to have witnesses that you choose be compelled to appear and testify on your behalf?
Yes.
Do you know how to request that witnesses be compelled to appear on your behalf? To subpoena them.
If you're asking whether I know administrative procedure, I wonder, Your Honor, is this a court of equity or is this an administrative court?
So do you understand that if you represent yourself, you're on your own? I can't tell you or even advise you how you should try your case.
I am here propria persona.
You know that you have the right to represent yourself, but by doing so, you could take a great risk of not properly presenting your case. Do you understand that you will be required to abide by the Colorado Rules of Evidence and the Colorado Rules of Criminal Procedure? And do you understand the defenses to the offenses by which you're charged? Do you understand that an attorney would be familiar with defenses and requirements to raise such defenses on your behalf? Do you understand that you must proceed by calling witnesses and asking them questions, not arguing or making speeches, but asking appropriate questions, and that you will not be permitted to tell the jury matters that you wish for them to consider as evidence during the examination of other witnesses? Do you understand that it would be much easier for an attorney to contact potential witnesses, gather information, and question witnesses, and to present your case than it would be for you? All right. At this point, I'm going to find that you are aware of the rights that you have and that you're giving up by waiving your right to counsel. You are not choosing to cooperate with the process. But at this point, the court's going to find that you've knowingly, voluntarily, and intelligently waived your right to counsel. We'll go ahead and enter a not guilty plea and get the case set for trial.
I object, Your Honor.
You're the one that asked me to set it for a trial. If you don't want it set for trial, I'm happy to set it for something else. Do you still want it set for a jury trial?
Yes.
Okay. That includes a not guilty plea.
Well, let the record show that I have not entered a plea, that the plea was made for me.
You're asking for me to set it for a jury trial. That requires the entry of a not guilty plea. So the court will receive a not guilty plea today. I'll find that speedy trial runs on October 3rd. I'll order that motions be filed on or before May 4th. That'll also be the deadline for endorsement of witnesses and defenses. We'll set a half-hour motions hearing, trial readiness, and jury trial dates. And let's see what dates we have.
Motions hearing at 3:30.
Okay, June 15th at 3:30 for motions.
Trial will be July 29th.
Okay, July 29th at 8 o'clock for jury trial. Okay, July 14th at 11 o'clock for trial readiness. Trial readiness will be the last day the court will accept any plea agreements in the case. The court will issue a written pretrial order, and we'll print an extra copy for you today so you have those. Be sure to look because there are some additional deadlines and information in there about doing jury instructions and things like that. All right. Thank you very much.
Thank you, Your Honor.
A man named Robert Gies appeared in court for a traffic-related case involving charges of driving with a revoked license and careless driving. At the beginning of the hearing, the judge asked whether he wanted to hire a lawyer, request a public defender, or represent himself. Instead of giving a direct answer, Robert introduced himself using unusual legal language. He stated that he was appearing in his own capacity, described himself as a natural person rather than a U.S. citizen or legal corporation, and claimed that several court records about him were inaccurate. He also mentioned filing legal documents, personam, including a discovery request and an affidavit, and questioned whether the court had reviewed them. The judge explained that discovery matters are handled through the prosecutor's office rather than by the court. The prosecutor confirmed that Robert's request had been received and was being processed. Robert argued that the case should not move forward until those issues had been addressed. The judge explained that the proceedings would continue according to normal court procedure. After a short break, the prosecutor informed the judge that Robert intended to take his case to trial instead of accepting any plea offer. Robert objected to the prosecutor's statement that he would enter a not guilty plea, saying he personally was not making any plea and did not consent to one being entered on his behalf. The judge explained that under court rules, requesting a jury trial requires the court to record a not guilty plea so the case can proceed. The judge then questioned Robert to ensure that he understood his constitutional rights, including his right to an attorney, his right to remain silent, and his right to a jury trial. Robert confirmed that he wished to represent himself and declined the offer of a public defender. Throughout the discussion, he repeatedly used his own legal terminology and occasionally declined to answer certain questions, instead asking about the nature of the court and its authority. After reviewing his responses, the judge concluded that Robert had knowingly and voluntarily chosen to represent himself. Although Robert continued to object to the court entering a not guilty plea on his behalf, he also confirmed that he wanted a jury trial. The judge explained that entering a not guilty plea was simply the legal step required to schedule that trial. Finally, the court set deadlines for filing motions, identifying witnesses, and preparing the case. Dates were scheduled for a motions hearing, a trial readiness conference, and the jury trial itself. The judge also informed Robert that he would receive written instructions explaining the remaining deadlines and court procedures. During the hearing ended with the case officially scheduled for trial.